the discipline of the bench. And they were worried that you could disbar them or hound them or make them their lives really terrible. What I'm asking is, why should these internal investigations be kept secret when in fact you said you wanted the judiciary to serve as the gold standard of integrity? We only know that there have been the Leonen Committee, two retired justices, and then a judge in Laguna who was dismissed, an encoder who was suspended. But the three other justices who had been investigated, we don't know of the full details. So why should these internal investigations, ma'am, be kept secret?
I'm sorry, Malu, I don't know who these three other justices are. In the Supreme Court?
Well, the reports have it that Ma'am Arlene was dealing with four judges, not justices, four judges, I'm sorry. And
Four
that,
judges, lower court judges.
That's right. And that there are two other fixers, according to the court administrator, who worked the rounds of the judiciary.
The two other names. I'm sure that Attorney Te has already given you the text copy of our report. And there is already a rundown of how many judges, non-judge personnel, lawyers we have dismissed from either the judicial service or from being members of the bar. So the drive to weed out those against whom cases warranting dismissal have been really pursued with vigor. That is true, and you already have a list. But you are actually asking us to justify the sensitive matter by which we are handling these investigations. Well, one, you must understand that the judiciary is an institution that has had a long tradition, including how they interact with each other. And I am sensitive to the fact that there have been leaderships that have been prompt to raise red flags, and there have been leaderships that have been slack in raising these red flags. In other words, there has not been consistency also. The message has not been consistent. Now, in keeping with my analogy of a big ship, if you just suddenly abruptly say that these kinds of fraternizing that had been happening in the past and that had not been called attention to are now suddenly going to merit penalties, then the question of fairness becomes a very important question. Because some judges, some of our best judges, may have just seen that that was a fraternal practice and that they have never been alerted to the fact that there was already a possible crossing of the line. In other words, it is possible that the bright red line that should have always been drawn, that should have been marking what was acceptable conduct and what was not, it had faded. And it had faded into something that was just suggestion. No? So it is because of the fact that we do not want to destroy lives that we are careful about it. Not that we are going to cover up for any crime or wrongdoing. You can be assured of that. And at the proper time, the results, even of the administrative cases, will be made public. It's just that the process, we are being very careful of the process because of the number of personalities involved. The fact that their careers are also important to us because of the fact that in some of the allegations, you really don't have any evidence to go by. So you just, I think with respect to this particular Ma'am Arlene controversy, the fact that there are 4 complaints already, that's already very, very serious. That's, in our world, that is already very serious. So I hope we can ask for more time from the public for us to be able to come up with reports that can really be fully disclosed. Is that okay, Malu?
So you ask your second question now? Okay.
Ma'am, i-follow up ko lang para tapos po yung tanong ni Mr. Punay tungkol sa SALN. Maganda po na nagkaroon ng guidelines ng Supreme Court because that was movement forward under the watch of Acting Chief Justice at that time, Antonio Carpio. Your own views are now being heard about it. You know, how far would you push the envelope, so to speak, in terms of transparency in the disclosure of asset records? But we are really confounded, having been practitioners of getting SALNs all over from various government agencies. The question is, why should the Supreme Court have its own guidelines in the release of SALNs that are very tedious, very costly, very unreasonable perhaps to ordinary citizens who would have to have their requests notarized and have to submit articles of incorporation, barangay certificates, etc., and actually argue for the merit of the request. And for that matter, the case of the BIR also that had requested, it's a government agency. I don't know why, well, except for the Supreme Court, the House of Representatives, it must be said, doesn't also give copies of its SALNs, only a summary. So you're far better than the House of Representatives in that regard. But question is, the Constitution and Republic Act 6713 doesn't speak of guidelines. It only says reasonable costs, reasonable procedures. But here you have the court entrusting the en banc with powers to decide on requests for SALNs. Why should you be very special in regard to requests for SALN disclosure?
Well, you already said that we are far better than the House of Representatives.
Still special.
The SALN law identifies the Supreme Court as the institution that should define the guidelines.
Yes, ma'am.
Correct?
Well,
So it is not for the entire judiciary. So it is not acting outside of its bounds. Now, you have said that it was very time-consuming for you to do
Costly.
that. I don't know whether the law students of former Senator Rene Sagisag found it time-consuming because for them it wasn't difficult at all. At least I thought it wasn't because they were able to finally get copies of the SALN. Now you should appreciate that this comes as a major improvement over the former regime that had prohibited the disclosure of the SALNs except for very, very limited reasons. It was in 2012 that we decided with full compliance of the SALN law. Now you are going to ask us to push further. Give it a little rest. It's just been 2 years. For all you know, you need consensus. From a period in which there was non-disclosure to a period of disclosure, every step has to be fully discussed and debated. Now, Edu is trying to push the envelope further. He's trying to talk about a lifestyle check. Some justices are okay with the lifestyle check. Some may not be comfortable with the lifestyle check. In any case, whatever rule we will have to generate will have to apply to all. So you have to build consensus towards that. Maybe the issue is really you are a bit impatient with our what you call can be a more revolutionary way of presenting our income vis-a-vis our public compensation. Maybe that is the issue. But perhaps we have beaten this issue also too much because what can you squeeze out of that statement? Are you saying that the ombudsman cannot pursue us already? The ombudsman has all the abilities to do that already. She has all the powers in law. You know, even for tax purposes, our alpha list is with Commissioner Henares. What information does she have that she cannot obtain? The reason for the non-grant of the request of Commissioner Henares was very clearly stated already in Attorney Tess' press statement. If you are the Supreme Court and you have many, many cases of the Commissioner of Internal Revenue before you, that is the same with the Court of Tax Appeals. And then you suddenly find yourself being asked, kindly deliver all your SALNs for all of you, because we are conducting a tax fraud investigation and because of Ma'am Arlene. Now, with respect to Ma'am Arlene, I don't think she has any idea that so far all the personalities are only the only relations that have been discovered so far are trial court judges. But she doesn't ask for their SALNs. Only the SALNs of 3 collegial courts. Some, 2 of which are heavily hearing her cases, one of which is